elevate your mind. Live your life without limits, no more wasting time. Don't forget to stay focused while continuing to stay on the grind. Keep your vision real tight, then your future be bright until the finish line.
Good morning, Living Your Life Without Limits family. Thank you for joining me today for this special presentation on estate planning. I am so excited to have my guests with me today, and it's none other than my esteemed guest, Maria Primushko. I believe I pronounced that right.
That's good enough.
Okay. I want to tell you a little bit about Miss Maria. She is an estate planner expert, and she is a well-respected member of the American Academy of Estate Planning Attorneys. Maria, thank you so much for joining us at Living Your Life Without Limits today. It's an honor to have you.
Well, Shannon, it is my honor. What you do for your listeners, for your viewers, it's amazing what you do. I've looked what you've done before, and that's exactly what people need. Living life without limits. And you can add to that, my motto is peace of mind.
Absolutely. I want you to know, Maria, and also the viewers, this particular episode was viewer-driven. Okay. I actually had viewers reach out to me and ask that I bring an estate attorney to talk about these issues. So with Living Your Life Without Limits, one of the things that I pride myself on as a host is listening to the viewers and what they need. Good. So again, I thank you for making time because this was a viewer requested episode. So just before we get into some of that, why don't you tell us a little bit about your background? I understand you knew at a very early age that you wanted to become an attorney. Talk a little bit about that for us.
Yes, back in seventh grade, I decided to become an attorney because I was that girl fighting bullies, making sure everything's in order, and so I did. I graduated, as you could probably tell from my accent, you know now, but your listeners don't. I'm from Russia, so I grew up back in Russia. So I graduated St. Petersburg State University's. With the degree of jurisprudence, became an attorney in Russia, and things doesn't matter. It's a history. Right. I came here with my husband to the United States, to Los Angeles. I'm grateful to this country. I appreciate everything that it's done to me. So we went. I'm living American dream. So we came here with the two suitcases and started building our life. Everything that America stands for. We've utilized, we used everything, all the possibilities that are present here, that are available to anyone. So everyone who wants to succeed, to make his or her life matter, can do it here.
Excellent. Thank you for that background. Not only is it, now we're getting ready to go into the segue of this conversation, but if the timing could not be more better to talk about estate planning with what's going on with the coronavirus and many unexpected and sudden deaths that have happened, which our prayers go out to families and loved ones. And I know there's a lot of fear that's going on within not only America, but across the world. But putting things in perspective with everything, planning is so important. So talk to us, what is exactly estate planning for the viewers that may not even know what that is?
Yes, first of all, the viewers who requested this episode from you, I congratulate people. I'm so happy every time I hear when people are interested and when starting express interest and asking questions, what do they do? Because there is almost no information available for general public. Over 70% of Americans have no estate plan whatsoever.
Wow.
That is why...
That's a huge number.
That is why our probate court is overwhelmed with cases, with probate cases, which can last almost 2 years, even if everything is up to date, everybody agrees with each other, etc. Also, as you mentioned right now, well, estate planning is always an issue. Every single person over the age of 18 must have certain documents in place. people confuse estate planning sometimes. People ask, oh, estate, you can buy me a house. I'm like, no, real estate planning, no, that's not the way to do. Sometimes people think estate planning means that you have to have a mansion on Mulholland Drive or in Beverly Hills.
Yes.
No, as I told, over the age of 18, it could be single parent with a child, one bank account. You must have certain documents in place. It depends what kind of planning you do, but every person has to have certain planning.
So what exactly is estate planning, just so we can break it down for the
estate
listener
planning
to be able to understand?
Of course. So my motto is a peace of mind.
Okay.
So estate planning, it answers all the what if questions in your life. What if I become disabled? What if I die? What if my family member passes away? What if my family member becomes disabled? I have young children. What if there is a car accident? Who takes the child? So each and single what if question in your life that people in general, psychologically, we ask those questions ourselves when we go to sleep, when we board an airplane. We don't know what life will bring us, especially nowadays with this coronavirus. I'm not a fan of panicking, but I'm a fan of being prepared. Planning, being prepared and planning for all that life that can hit you with. People have businesses, people have bank accounts, people that have properties. If person has nothing prepared as far as documents, power of attorney, healthcare directive, will, HIPAA form, living trust, very important. Then when life happens, their family and their life becomes a chaos.
So you talked about there's important documents that we need to have within those estate planning. So what are those 4 documents, and then can you define what they cover?
Okay. First of all, it's power of attorney.
Okay.
We'll start with young adults. Let's say I do have like college packages or young adults packages. Everyone over the age of 18 has to have power of attorney, which gives whoever has the power of attorney right to act on your behalf should something happen to you legally and financially.
Okay.
So we can go to the bank with power of attorney and act on behalf of the person who is disabled now or not available otherwise.
Okay.
Then a healthcare directive, also power of attorney, allowing assigned person to speak on our behalf. So let's say I issue power of attorney, and those are mine decisions. When you have something in order, that person, your power of attorney, just simply have to read what you've decided, your choices. If you want to be on life support, if you don't want to be alive, if you want your organs to be donated, whatever you decide, and you make those decisions. You don't leave your kids making those hard decisions, not knowing, one kid wants, no, I want my mom on support. The other kids like stop the misery, let's take her off. So you limit, you cancel it all
And
out.
I just want to add a little bit to that, being in the healthcare field for over 28 years. And I personally know that this can be very trying during the time in a decision making where when somebody is on life support and maybe their organs are already gone and one person wants one thing and another, so it can be a very traumatic thing and bring a lot of discord. The other thing on clarifying with this, it doesn't have to be one and the same. Healthcare power of attorney person can be totally different than the person that governs your finance. Is that correct?
Exactly.
Okay, because I know that you can have somebody that's just designated as your healthcare power of attorney and someone different over your finance. Don't necessarily have to be one and the same.
For example, I had my client, he's like, okay, I'll allow my wife handle my healthcare decisions. She loves me, I think, and she will do what I said, but financially, she has no clue.
Exactly.
And we don't have to force her to do something she doesn't know.
Correct.
Or don't feel comfortable proceeding. So we make decisions. We know who will be the best person to do what on your behalf.
I like something you just said, because in selecting the individuals, before we get to the third and the fourth one, it needs to be someone that you know that have the knowledge to execute in the experience on your behalf.
Exactly.
Not just based on connection and relationship.
No, not necessarily. It's a trust,
Right.
bottom lines. Because when you don't have those documents and someone becomes disabled, let's say husband and wife, let's make our husband disabled.
Yes.
Okay.
Yeah.
Now wife has to step in, or kids, adult kids. And you have to apply for conservatorship
Yes.
in probate court, which is time-consuming, expensive. I would charge not less than $8,000 some attorneys,
Correct.
$10,000, etc.
I know someone went through that. Very
Yes,
expensive.
and expensive, humiliating, because that person has to be actually willed in into the courtroom, and they will decide, measure, disable. It is humiliating. It is public. Moreover, we don't know who judge will appoint as your conservator. You don't have any decision maker. You're not a decision maker anymore. The judge will decide, and it's out of your control. They may appoint a child who's irresponsible with money because other child, good one, doesn't want to do anything or is not available. So it is my objective is for people to be in control. Don't let government interfere, get into your life, put a mug on your file, forget about it for a while, and make decisions for you and for your family. Be in charge.
Excellent. So we said power of attorney, healthcare directive, and what's number 3?
HIPAA form. It's authorization to release information to your to whoever you appointed in your healthcare directive. It is very important, especially for young adults, kids. Those kids, adults, 18-year-olds leaving for college, and God forbid something happens. Doctors have right not to talk to parents,
Correct.
not to disclose information because it's protected. But if you have, and they're still your babies,
Right,
they're not
exactly.
adults.
Yeah.
You have to take
Yeah,
care of them.
yeah.
So you have to have those documents in place, just enough, and it's peace of mind. You know what's going to happen. You pull up that paper, you provide it to whoever is in charge, and you can step in and act on behalf of your loved one. It's very
Excellent.
important.
Now, what's that 4th one?
Then we have, sometimes it's sufficient for people to have just a will package. If the estate here in California, if it's under 150,000, probate is not necessary. So in that case, we can have just will package where you devise and will accordingly what you want to do with whatever you own. However, here in California, especially in Los Angeles County and other counties, it's very hard for people to have something less than 150,000. It does happen for every, working individuals, and they do have to have their plan as well. But for something more, over 150,000 estate, which counts everything: your house, your bank accounts, your insurance policies, your accounts in with the brokerage. Nowadays they're all plummeted, but yes, you have to have living trust for that.
That you segued into my next question. So which is better, living trust versus a will, and what is the difference?
Well, for me, living trusts are. There are certain situations when will is sufficient if the estate is under 150,000, and if you have, let's say, there is a parent and one child, or there is a couple and they want to leave everything to charity, whereas something is very straightforward.
Okay.
There are not many options to play with.
Okay, so that's the defining difference.
I would see for my clients.
Under
yes.
150,000, and if it's very straightforward,
And simple,
where you know exactly there's no
because
conflict
because
anymore.
if the estate is more than $150,000, and if you've created a will, everything will still go to probate. So if you have a will, it is your estate is still subject to probate. It will just give judge an idea how you wanted everything to be distributed. However, it is still expensive, painful. A lot of people, when there is a probate with a will, anyone can jump into the process. Let's say there was a caregiver for the last 2 weeks caring for an older person. They can jump into probate process and say, hey, your grandpa promised me $10,000.
Really?
And they may not have any basis or they have to prove it, but anyone can join the probate process. Whereas when you have living trust, it is much harder to do because when there's living trust, it's like separate creature, living creature that has to go with you along your life. It is standby device. You have to, it changes with your life. New kids, new properties, new wives, whatever life happens, you have to amend it. And I lost my train of thought.
That's okay. I wanted to ask you with that, and thank you for that clarification, because when did it switch? Because all you used to hear years ago was will, and then you started hearing the term living trust. Is it because it was more litigation that kind of brought this about with the change?
Yes. So I kind of remember where we left off. So, but with the living trust, we can, for person to initiate the contest, to contest the trust, saying that they have to be awarded something, person has to open the case in probate. They have to hire an attorney usually, and for that the contingency, the retainer will be pretty significant. It's going to be about $10,000. I don't think anybody would get anything so less than that. So person has to have some real evidence that there was some abuse or someone took advantage of the trustor who didn't give them their share. So there have to be something very significant to contest it. Or we have to talk about millions and millions of dollars.
Exactly.
Most of my clients don't qualify. So getting back to your question, I apologize for messing
that's
up.
okay. No.
So, no, trusts, concept of trust is hundreds years old. It's been known, but unfortunately, everyday Americans are not aware of it. It still remains the privilege of rich people because they have attorneys who proficient in it, who know how to protect their wealth and their assets. That's how you have all those trust babies, kids with trust money, they do whatever they want and they're not responsible for anything because they personally have no money. And that's how rich people continue their legacy. And it's not, there's nothing bad about it. We say rich because, no, it's good. Wealthy, it's good because they know what they do. They hire right attorneys who know the not the tricks, but the ways to preserve their wealth and continue it for generations. Unfortunately, middle-class people don't know about it, or they go and create simple will and they go to probate, or they go to create simple trust. There is also called bare bones trust, which most CPAs and sometimes attorneys create simple trust, which gives, hopefully if done correctly, avoids probate and gives everything outright to heirs, let's say. And there are certain it's very questionable because not every kid or adult child is ready to receive $1 million inheritance or even $300,000 inheritance. They go and spend it off. Whereas knowledgeable attorneys create ways to preserve this wealth, not allowing kid to, spend it in Las Vegas or be involved in schemes, like, oh, I heard you got an inheritance, there's huge, there's great business, big business opportunity. Let's just invest and we'll move on. It's very scary. Also divorces, if not done correctly, your girl got her inheritance, and if not done correctly, if husband decides to divorce her, he can get half of it. because people commingle, to community property. So there's
Especially in
certain,
California. I think.
yes. So there's certain ways. Trust just gives you the way of power, continuing your legacy. Because if you create living trust, it means that you care about your loved ones. You don't allow them to become part of this probate disaster. They will know exactly, should life strike, happen, disability or death, they will know exactly what to do, where to go, and how everything's going to be distributed. So family has peace of mind. They hold hands.
Yes.
They're mourning. They know they're being family, not trying to, there are no less fights. There is no, because they know
Adversarial to each other,
adversarial, and they respect you. They understand that person who created this document loved them, and that person is leaving a legacy.
Yes. Now, I've heard the term about the trust, and then there is the trust funded or not funded. What's the difference in there? So I hope these are questions that have come up that are very important here. Because there's trust and then the trusts that are not funded. So it's a living document that's been notarized, it's in the courts, but there's no assets in it. What's better?
Oh, well, there's no question what's better. The question is if there is living trust or not.
Yes.
I've had people come to me and ask to review their trusts, and they say, oh, I got it from LegalZoom, or somebody created it for me. And they bring it to me. It's a nice package, usually, and I open it up, and it's not even signed and notarized. People don't know. They just received the package from mail. They're happy. Oh, check mark. We've done what we were supposed to do. Or it is signed and notarized. Everything looks fine. But when I ask them, okay, have you transferred your property from your name to the name of trust?
That's it.
Why? What's going on? I'm not dead. I still have to be in control. So people don't know. So that's why you have to get the right expertise, because for trust concept to work, you have to fund it. Transferring the house, your assets from your personal name to the name of the trust. But you're still in control. You can do whatever you want. If it is living trust, you can change it, you can amend it, you can sell your property, you can refinance, you can do whatever you want. But you're still in power. And if trust is funded, then it's legitimate trust.
I'm so glad I asked that, because there's many people that have created documents, but they haven't funded the trust. They're just saying, well, I have it there if something happens to me. And is that true? If something happens to me, do they still end up going into a probate situation?
Yeah, if trust is not funded completely, yes, probate is your next step, because it's not valid. That's why in my practice, I make sure trusts are funded. I don't trust my clients. I make sure I have them sign the deed if there's real property involved, sign the deed in front of notary, and I don't give it to them. I have it. I send it myself to the county. I supervise it. When it comes back to me, everything looks fine. I see that it's been filed, then I send it back to my clients. Also, I make sure all the accounts or other types of assets been transferred in the name of trust. I give my clients the letters and sometimes talk on their behalf. Not everyone is savvy to manage the situation. So I do help with funding.
Yeah. How does that relate in terms of taxes and tax filing and so forth? Because some people have brought those concerns of, well, if I fund the house into the trust, where in the tax breaks for me individually being a homeowner versus not in those things? Can you talk on that a little bit?
Yes, of course. Good question. When you transfer your house into the name of trust, there's no tax consequences. We fill out special form that is filed along with the deed, saying that no property tax reassessment has to be done because this is this type of transaction. It's not taxed.
Okay.
And in general, living trusts, everything still remains under the social security of the trustor.
I see.
So you still file as usual, no consequences. If there's sometimes need of creating an irrevocable trust, it could be done for asset protection or for medical protection.
So explain that irrevocable so people will understand.
Yes, so if you create irrevocable trust, then there's tax consequence because this irrevocable trust becomes completely separate creature out of the trustor, and we have to file forms with IRS creating special EIN number for this trust. Irrevocable trusts, one of the reasons people create it, it's for medical protection, for long-term care. To get long-term care benefits, you can, what are the ways? Spend all of your money because you can qualify if you have 2,000, more than 2,000 in your account. You can have a house, you can have a car, but you can have liquid money. So people, in order to continue have money and qualify for medical, people create irrevocable trust, medical trusts, where that's how you see rich people who plan, older people living in Beverly Hills, driving Rolls Royces, qualified for medical.
Wow.
Because they personally don't have anything. The trusts have everything. And it's legacy trust for their children, grandchildren, but they still can get certain benefits from that. And again, unfortunately, only people who have access to these boutique law firms somewhere in mezzanine, that they know how to operate. And
so, Ms. Maria, you are bringing strong knowledge to us today, and I am my eyes are just popping out on some of these things that you're saying of enthusiasm, because this is what's needed and beneficial, especially for middle class, working, hardworking people to understand the differences. So on this so I thank you again. On this part of this trust, irrevocable versus not, I'll play devil's advocate for a minute. So 30, I'm not 30, I wish I was, but I'm older already. 30-year-old that's doing pretty well for themselves and want to do the right things, maybe listening or say, yes, I'm going to put my ducks in a row. Which one is advised of them, or is it, which one should they look at? I know each case is different, but each
case is different, but for young families, it's considered young families.
Yes, yeah, that's what I'm saying.
40s, you consider young families.
Yes.
I would suggest revocable living trust, because you still want to
be able to do things,
operate and manage your affairs. You don't know what you're going to do next in your life, but it is so necessary, especially when young kids involved, minor. Because my question to people, there is a car accident. Thank God everyone's alive, and child is fine because we have car seats. Parents are taken to the hospital. Who gets the child? They say grandparent or uncle or brother. No, Child Protective Services will come for the child. And for child, of course, it will be sorted out if parents are alive eventually, but it will take a couple of days or a week to figure things out. And child just having stress of being in a car accident, parents were taken somewhere, and they're taking somewhere else to good men and women, but they don't know, to some facility or some home. It is so stressful and completely avoidable. What I do for my clients, whenever there's young minor kids or young adults until the age of 25. So for younger kids, I provide families with the temporary guardianship form for free. It's just included in the package, and where they sign and notarize who can take the child. It's in your glove compartment, it's in a daycare facility, at school. Peace of mind, you know exactly what's going to happen. For young adults as well, I do the Power of Attorney Healthcare Directive and HIPAA form. Again, peace of mind, you're in control, you know exactly what's going to happen should life strike. And we don't know when it happens because, as you can see, I'm on my donut pillow. I tripped backwards and fell and was out for weeks. So we never know.
Excellent. So going to another question, out of state. I live in one state. I filed these documents. I was proactive. in another state, can it be contested from one state to another? Or it was very old? Had it years ago, person, say a loved one passed and they had an old will or an old living trust of some sort many years ago, and now we're at this point and, you know, it was filed in another state. How does that work out? Can that be somewhat little bit?
It may be an issue. If done correctly, living trust created correctly, they should withstand the time.
Okay.
And if you move permanently to a different state, I would strongly suggest that you go to the attorney, local attorney, and have them review your trust and see if it will work. It should, and although under the laws of the state where it was created. So maybe if you permanently move to a different state, it is better to revise
so
the
it
trust.
may be needing to be amended. So that's very important because we have viewers from all over the country and out of the country that actually watch the show.
Nice.
So we're multicultural and multi-generational and multinational. So I'm grateful to all the viewers. But that's very important. So that was one of the questions, because what governs one state, there may need to be modification in other states. So one of the things is, if you haven't, or if you're planning and you're going to be relocating, that if you prepare one after seeing this episode and then 2-3 years later you decide to move to another state, that needs to be reviewed to make sure it lines up to that state, just to avoid probate and litigation along the way.
I would suggest so.
Okay. Very good. That's very helpful. So, a question from one of the viewers. If a person deceased left a living trust, do the heirs avoid probate altogether?
If done correctly.
Okay.
If it was funded, then yes.
Okay. So in the case of it not being funded, what would have to happen?
It depends. If, let's say, there were situations when people have living trust, they funded everything, they purchase a new house. 2 months go by and person dies. They pass away, and they didn't transfer this new house into the name of trust. They didn't fund. Then we have to, usually attorney will have to go to probate court, but it's relatively quick and inexpensive procedure. You will have to show the judge, listen, there is a trust. Everything else has been funded into the name of the trust. This new house is very recent, and they just didn't have time due to illness or something to plan to manage the documents. Then it shows your intent, that it shows, oh yes, indeed, they meant this property to be in the trust. And in my trust documents, there's pour over will,
yes,
meaning that it is your intent, so whatever property you have anywhere in the world, it is your intent to have it in the name of the trust. And usually 96% judges approve it. On the other hand, if nothing has been transferred in the name of the trust, and you have this just beautiful document on your shelf, it means nothing. It will be viewed as a will, and it will still go to probate.
Now, say for instance, a person, taking what you just said, say they created the trust a year ago, but didn't fund it, but decided after they watched the show, I need to fund that. Is it ever too late to fund it? Okay. So there's no time limit from the time that they originally set it up until now.
No,
as long as they're breathing. As long as they're breathing, right?
And in right state of mind.
Yeah, right. Okay.
Because sometimes I've heard situation, people come, oh, my father was diagnosed with dementia. Let's create a trust real fast. I'm sorry, it's too late. He doesn't have capacity to sign the document.
So that's the key. Still breathing and have capacity to make their own individual decisions.
Exactly.
But it's not too late for the people that be in that situation.
And please do it right away, yes.
Okay, excellent. Especially while we have a right mind, right? Don't try to play on me when I'm not there. Okay.
Oh, you wouldn't know how much abuse going on. I just had a client where there was a caretaker, older person, and there was a caregiver. And that caregiver took this person, this lady, to the local notary, and they made her, in good ways, sign a trust.
Oh my goodness.
That caregiver was generous enough, taking only a third of her estate, but managed to take a lot of, like, 200,000 from her account, having power of attorney.
And the notary was in on it too.
Apparently, they filed
Scam.
police report. Yes, so thank God, family members were caught it fast. So we made all the changes, amended. I made it rush. Super important. I drove to Downey to help it notarize and everything.
So there's a lot of fiduciary abuse that happens
with elders, especially. It is so hard to watch. So you have to watch your elders and know who's around and who's taking care of them, and have those documents, powers of attorneys, signed while these parents, old elders, are in right state of mind.
And
because
probably
afterwards,
having them put secure somewhere, right? Because people also go and try to manipulate.
Or have checks, some kind of checks and balances. Like in my trust that I create, there is a special position of trust protector or special co-trustee, where usually trustors appoint me or somebody they really trust but don't want to bother on regular basis. So it's a like trust protector. So if let's say they're minors and there's trustee and caregiver and guardian says, hey, they can come to me and say, hey, this trustee something's wrong, they're not doing the right thing. Or I couldn't receive finances for minors to take care of them, or if there's older person. So whoever is involved, they can come up to me or to that person, trust protector, and ask for action, like without spending money and going to court.
Also, an accounting of what was spent, right?
Yes.
So you can also review to make sure the money is being appropriated correctly,
course.
right?
Yes,
So.
very important.
Okay. What's the average cost for estate planning for us average people that are just hardworking on the grind? What will it run about? I know it varies case by case, but average cost thereabout.
Well, there are certain instances you don't want to bargains,
right?
Like parachutes,
yeah.
or plastic surgeon, or any surgeon for that. For that.
I've seen some bargain plastic surgery. You're like, oh,
yes.
You should have paid the full money.
I would say estate planning attorney is one of those categories, and you will see you can get a bargain. Like billboards will do trusts for you, $700, but no, there's always asterisks above it, and that asterisk means a lot. That you don't have this, that we have. You will get your bare bones trusts and without no instructions, etc. So my clients vary. It could be from separate documents, ancillary documents like powers of attorney, healthcare directive, to full-blown comprehensive trust with a lot of sub-trusts to take care of your kids, make sure money don't tinkle away. So general price for my trust now, for the comprehensive, for the big one, is $4,150. And let me tell you, it is not high amount.
No,
I'm very reasonable because
extremely. I will attest to that.
For the work I do, and the amount of work and the type of documents that I create, it is, and it's one-on-one personal plan. There's not going to be the same plan for any other family because everyone is unique. Because I dig in. I'm like a doctor. You can say I'm a Jewish doctor, but because when people come to me, I ask sometimes unusual questions. So I don't ask how many houses you have right away or accounts or how big is your estate. I go to the person. How are you? Married, not married, kids, not kids. Is your marriage good? Is it your first marriage, or we have blended family?
Get a comprehensive
I
view
have
of their
because
life.
Kids, good kids, kids with issues, because we have to protect each and every child differently.
Correct.
Because everybody's situation is different. And that's why it's the best plan is the plan that is tailored to your particular situation.
I love that. It's just like insurance. You know, there's a whole lot of insurances on the market, but when you have an insurance, it may cost you a little bit more, but you want the peace of mind that, heaven forbid,
Yes.
something happens, you walk away
Covered.
from it and don't worry about it.
Exactly.
And that's how I see estate planning. We
Yes.
want to keep it in the same vein, that when you leave, you don't have to worry about it. You don't want to use it, but if you have
Exactly.
to use it,
It's
it's
there.
there and the process runs smooth. And that's what I hear you saying
That's
through this
exactly
whole process, is
how
that you wanted to
We call
run
it
smooth.
standby device. And believe me, if you go to probate, if no documents are executed, average probate takes 25 to 35% out of whole estate. Attorney's fees, court fees, accountants, appraisals, all kinds of people involved.
And the years, the
And
time.
years
Let's
and
don't
time.
even, you can't factor up the time. Because sometimes I know property that have gone through probate. My grandmother, God rest her soul, she was appointed as the one over probate
Yes.
some years ago. And it took years to get some family
Yes.
property settled. So it didn't happen right away.
I know.
And it was defaulted to her in the whole piece. So it's years, and you can't even put a dollar factor on that part of it.
Exactly.
And ultimately, they had to end up selling the property and doing all this kind of a thing. And it's
Years, and it's stress. People,
Yes.
your family has to be involved in that, and it's tension among
Yes,
siblings, and
yes.
who does what, and who do they think
Yes.
did what, and it's so
Yes.
unnecessary
It
and
is, very
totally
much so.
avoidable. So when sometimes clients have an issue with money, of course I understand that.
okay.
So we have payment
Payment
plans,
and
but
options they
if
can
people arrogant say, I don't need it, I'm like, please take my card and give it to your kids in case something happens. I'll be happy to represent them in probate, because in probate, a statutory fee that attorneys can charge is 3 to 4% here in
Yes.
Philadelphia, and it's much more than my fee.
Exactly.
But I'd rather create this trusts for people and documents to make sure they don't have to go through that anguish.
So as
And
we're
it's-
coming to the end of this, because there's a lot that we covered, and I want to get on a couple of things that you're doing right now, and then I know you got a special gift that you're going to offer to our Living Your Life Without Limits viewers and listeners. But if you had to frame up what is the most important takeaway, because there was a lot of great information here, and sometimes you know how we are. We have to hear it and hear it and hear it. But what will be what you wanted to absolutely leave with the viewers today and our listening audience that is very, very important that you want them to understand if I had to grab anything, what would that be?
That would be take charge of your life and have peace of mind for yourself. Now, it's not only for the future, it's for now. Because when people sign the documents, facial expressions change.
Yes.
Weight lifts from their shoulders. They smile, it's easier because they
Yes.
know what exactly is going to happen. So be in charge of your life and make the decision and act upon it. Because people procrastinate.
Yes.
And unfortunately, it becomes too late because tomorrow may never come, especially nowadays. Be prepared and be in charge of your life. That's I would say.
And those 4 documents, again, that's a must that
must.
everyone should have.
Power of attorney, healthcare directive, and HIPAA form. That's a must. 3 are the must. And then you can have a will or living trust,
Depending on your
what
situation. That's under
what you have
consultation.
what you have to do.
Now, you're involved in a lot of great things within the community, and you have some new appointments. Tell us a little bit about what you're doing on those things. Because I also know that you offer free training courses as well. But
Yes.
tell us what you're involved in now. I heard some exciting news as I walked into your lovely office today.
Thank you. I'm passionate about it.
Yes.
I want people to know, because as I told, the reason people don't plan is procrastination, one
Yes.
thing, the other is lack of knowledge. So I want to eliminate at least this part of why people don't plan. So I give people information and knowledge of what they have to know, and then it's on them. If they act or not, I've done my job in spreading the word. So I'm giving speeches to different presentations, seminars to different groups, seniors, young adults, families, college, high schoolers and their families. Also, I'm part of the Suddenly 65, suddenly65.com.
Yes. Congratulations.
It's a great platform for knowledge-wise and activities and for seniors. Suddenly 65, they do. But I'm the only estate planning attorney giving advice and editor. I write articles for this great platform, and I'm member of different groups. Kiwanis, have you heard of Kiwanis?
No.
Kiwanis, they help children. It's for children. It's also
I heard it in your bio, but
yes.
I had never heard of it before.
I'm trying to be everywhere I can, provided, of course, I have to take time for my family. I have 3 kids. I have to manage that too. But I do go out and I talk to people and I explain the need and necessity of planning.
And I believe they were mentioning, Paula, your head of PR, you were just appointed into some women's leadership appointment, or did I get that right? Something of that nature?
Yes, I wouldn't want to. It's
Well, no,
a very good.
I want
It's
the
not
viewers to understand
Yes.
that you bring the knowledge
I
and
bring-
the recognition
Yes.
for the work that you've done. So please share. It's
No,
nothing wrong
it's
with
okay.
it.
And that's also for me to, because women are lately becoming more and more independent
Yes.
and taking charge of their lives.
By
and
default,
By
sometimes.
default, they have to.
Yeah.
No choice.
Yeah.
So I want to empower them as well. So I also do presentation for young families and like single mom. What can she do to plan? I mean, she doesn't. People say, "Oh, I'm just single mom. I have 9 to 5 job and I have a kid and a bank account. That's all I have. Why do I have to plan?" But yes, you do have to plan because you're still responsible for your child. You're still responsible for his or her well-being in the future and for yourself. That's why I provide planning. So I'm not looking just for millionaires wanting to create their plans. I want to help everybody and empower and educate women.
Excellent.
Yes, this organization that helps abused and battered
Yes,
women.
that's what I wanted you to bring out, yes.
When I heard about it, we met at the event with this lady, Trish. This is amazing. I'm becoming a part of the team to go in to that facility and help and guide people, ladies, how they can general mentorship, giving the power.
Excellent.
You know, I mean, my scenario is pretty powerful, the story I give, that anybody can succeed. And the way that you end up now at this situation, being abused, battered, your self-esteem is low, you don't see the light in front of the tunnel. I help them by the talking to them, give them courage. Also legal issues, very important. Many of them require family law situation because they're divorces and custody fights for kids. I connect them with the family law attorneys that I know, ladies as well, who can step in and provide pro bono and free help. And of course, that's all I do is for free. Over
Yes,
there.
yes.
It is very
So she's
powerful.
doing a lot of community work, family, and one of the things that she's going to announce today, which I'm very excited, she's so committed to helping the everyday person from all walks of life, that Miss Maria is going to announce that with using the Living Your Life Without Limits code, that she's going to give a special discount of 25% off for 2 months. So for the next 2 months from the day that this show airs, and we're going to put that on the tag below just so you know exactly, if you come to her office, you will receive 25% off of the services for you to start your estate planning. Or maybe you already have an estate plan in place and need her to review that to make sure, as she said, it's airtight, that you don't have any loose ends, or it's been funded so you don't run into any issues. I want to thank you again, Maria, for all of your information and knowledge. How can the viewers reach you?
The easiest way is they can email.
Okay.
It is mvp@mvplawgroupla.com, and I believe you'll have the
I will also
information.
have it up at the end.
Also, telephone number 818-213-7400, line specifically designed for appointments and consultations.
And you offer a 30-minute consultation free regardless to any services.
I'll talk to you, I'll hear you, I'll explain what are the options for your particular situation, and then we'll decide if you want to proceed or not. The best part in my meeting is that if you say no, that's totally fine. I'm going to be fine because I will know that I gave you the knowledge.
Absolutely.
And it's up to you how you want to proceed.
Absolutely. Well, family, you have it. This was something that some of our viewers, some of our Living Your Life Without Limit family members asked for, and I cannot think of a better person to have broke it down for us where we can get a greater understanding. There is so much going on in life today, and we started the year with planning on purpose or with a purpose. And not only about your vision for yourself for 2020, but planning to be prepared in the event something happens where you are not of physical sound mind or physical ability, or you have transferred over, decisions can be made on your behalf and on behalf of your loved ones. Take this very, very serious. Look at it as another part of your life to make sure you're whole, not just for now, but for future, and that your legacy is solid. Thank you, as always. I love you. I appreciate you. And remember to love yourself and take care of yourself, because guess what? You're worth it. Love you, and I'll see you next week. Thank you again, family. Have a blessed day. Bye-bye.
Thanks for joining us here at Living Your Life Without Limits with your host, Shannon Jackson. You always know she always brings you quality content all the time with each and every episode she creates, and that is just for you. You know, Shannon has done her part. Now's the time for you to do yours. You need to take action. Show her your love. Click on that subscribe button and get your content every single week. Quality content you can find nowhere else. Want more content on the go? No problem. Go to our website at livingyourlifewithoutlimits.com. We're also on the social media sites like Facebook, Instagram, Twitter, Reddit, LinkedIn, iTunes, and Spotify. Thanks again for joining us today. Tune in next time for another episode of Living Your Life Without Limits, and subscribe today.